would really appreciate a response from the Minister.
Carol Beaumont.
Thank you very much, Mr Chair. This has been a fascinating process indeed, and I was a member of the Select Committee that heard many of the submissions on what is a substantial bill and a far-reaching bill. And the fact that only 2 days ago, when I was speaking on this, we were still finalising negotiations on Labour's position at this point, and now we are supporting this bill. I have found the process, as others have commented, a very interesting one, and it's been fascinating as a still relatively new member of this House to watch a number of people operating to try and deal with what quite were fundamental concerns. And on Tuesday when I spoke on this bill, I referred to the role of Charles Chauvel, and I want to again acknowledge that work that Charles has done on raising what were fundamental concerns that the Labour Party had about the potential for the bill as it stood then to fundamentally affect human rights of New Zealand citizens. And so I am pleased to see that the Minister, the Honourable Simon Power, has addressed those concerns and dealt with them in a constructive manner, because there is no doubt that there are substantial problems with the current criminal procedure system. And certainly the Ministry of Justice has concluded, and I will repeat these because I don't think this bill, despite how far-reaching and substantial it is, deals with all of the issues of concern yet. And I have to say I wasn't aware that there was such a thing as a judicature bill. Terrible, can't even say it. Judicature bill. But now I know that there's this bill from 1908 that will also be part of reforming our justice system. But the issues of cost, excessive costs, and increasing the cost of the court system operating, and stress and inefficiency that's placing on the court system. And I think the Honourable Rick Barker explained that in quite a deal of passion, really, as a former Minister of Courts. Excessive delay. And I have to say that excessive delay has negative consequences both for the defendant but also for the victim of crime. And as Labour's Women's Affairs spokesperson, I am concerned about it from the point of view of victims of crime, that we do want a court system and a justice system that operates in a way that means that defendants and victims do not have to wait too long for justice. So that is certainly a reason for reforming the system, and this bill will assist, as the Honourable Simon Power has outlined in some detail, explaining where we will see improvements and delays, or reduced delays, in justice being served. Excessive complexity, and certainly this bill has been a really major attempt to categorise different criminal matters and to try and simplify it, and that is good, I think, a positive move forward. And outdated, and the Judicature Act is clearly one of those outdated parts of our legislative framework. But certainly the issue, for example, of thresholds around jury trials was a fundamental part of our legal framework, which we were very concerned about, and also acknowledging the Honourable John Boscawen in relation to the right to silence. These are cornerstone principles in our system, and so I think quite rightly various parties have said we would not support the bill in its previous form. Now, there are a number of people that really should be thanked for creating this monster bill. It is huge, isn't it? I mean, it is huge. And those are, first of all, the submitters. There were 72 submissions made, and we heard 35 of those submitters. And these were people who were submitting on very important technical matters. So we had a number of the legal profession and the judiciary submitting because they certainly wanted to make these reforms more robust and to make sure that we were not threatening fundamental elements of our justice system. And then, of course, interestingly, there were a number of submitters who specifically were submitting around matters to do with suppression orders and the internet and new media and so on. And as others have commented on, we still haven't got that sorted. we still haven't got the facts sorted that there are people who are using the internet and using social media getting around, Mr Chair, suppression orders. And so this will be, as others have said, a matter that will need to be dealt with in a future Parliament. So the bill itself, well, it is, as I said, a large, substantive piece of legislation, and it goes to, I've forgotten, here we are, 526 pages. 659 parts. And categorising of offences I've already mentioned, so a simplification. So we now go to 4 categories of offence, which is a major step forward. Then in Part 2 we have the proceedings and preliminary steps. So this is one of the areas where Labour's SOP would come into play, and I agree with the member Phil Twyford that it would be very helpful to have the Minister talk through the SOP in the name of Charles Chauvel. While I'm talking about people to thank, I forgot to mention the people who really should be thanked for the massive amount of work, and that is, of course, the officials who have worked on this legislation, and at great complexity and substance. So they also should be acknowledged in dealing with this. Pre-trial procedure is in Part 3, and of course we now have this issue of the jury threshold, and it was, I think, very interesting and helpful to have the comments made by the Honourable Rick Barker about how sentencing have changed this and therefore the relative significance of thresholds was very helpful, I think, to a number of people in here. But it is worth noting that the New Zealand Bill of Rights is being amended as part of this, and it is something that in Parliament we do need to be very aware of and take a great deal of cognisance of if we are looking at amending the Bill of Rights. And so certainly there was quite significant matters and concerns raised by the Attorney-General in relation to the bill and its form prior to the supplementary order paper that will change it. He raised many concerns. Part 4, of course, deals with the trial provisions, and again Labour's SOP has some relevance there, and it would be interesting to get, as I said, the Minister's comments. So Part 5, the general provisions, proceeding in the absence of the defendant. Part 6, around appeals. Part 7 is the provisions concerning jurisdiction of district courts. And Part 8, miscellaneous and transitional provisions. And Part 9, amendments to other enactments. So that's the scope of this bill. It is huge, and I am, as I said, I've been pleased and interested to watch how we have got to the point where this substantial change to our criminal procedures will be passed in this House. Thank you very much, Mr Chair.